Hey everybody, how's it going? Welcome back to Copper Jacket TV. So today I've got some more good Second Amendment news, which is always nice. The FPC has won their case in California, which is Campos V. Bonta. That's what we're going to be talking about today, so let's get to it. Now, before we go any further, if you wouldn't mind, hit that subscribe button. It's free. It only takes a second, but it helps me out quite a bit. And check out the sponsor of this channel, which is the USCCA. With your membership, you get self-defense liability insurance, concealed carry magazine, you get national reciprocity maps, online training and education, and so much more. That'll be down below. Okay, so let's go and talk about this victory in Campos V. Bonta. So if you guys either lived or visited California back in 2020, you'll remember that pretty much everything was locked down. And I mean pretty much everything. That included places that were protected by our rights. So, you had churches, you had FFLs, all this stuff was closed. Finally, due to court orders, these places, at least some of them, were allowed to reopen. So people went to their FFLs to pick up what they wanted, and they found themselves faced with another problem. That other problem was an enhanced waiting period. So in California as it stands right now, if you go to pick something up, there's a 10-day waiting period. That means that once you finish your paperwork, that's when the 10-day waiting period starts. Typically, the shops will have you pick it up on the 11th day just to be safe because California scrutinizes things so much out there. But what they were doing, during this time period, 2020, 2021, is they were having people wait 30 days or more. So you would go in, you'd pay for something, you'd do your paperwork for your background check and everything else, and then 30 plus days later, you would be able to go back and pick it up. Well, Campos V. Bonta challenged that, and that's where we got the win, because now the courts have told the DOJ that you can no longer do that. In California law, there are specific reasons why that 10-day waiting period might be extended. But one of those isn't because of everything that was going on at the time. So basically the DOJ said, look, we're just shorthanded. We don't have enough people. Well, too bad. That doesn't matter. The shop should still be able to release it regardless of whether or not you just don't have enough people, because not having enough people isn't one of the reasons to extend out somebody's wait 30 days. I mean, a 10-day waiting period, a 2-day, a 1-day waiting period to me is already unconstitutional. But you got people in California that have to wait a week and a half, almost 2 weeks as it is, and then you're going to extend it out a month? A month plus before it can be released? Here's the problem. When they get the background check in, so they need to, do the background check and stuff, that doesn't take very long. It's just a few button keystrokes, right? In order to find out whether or not somebody's eligible or not. That doesn't take very long. Most of the time, it's done that same day. So the rest of the time, the other 9 days, you're just sitting around waiting while they already know that they're going to be releasing it to you. And that is what most people thought was happening here during this 30-day time period. They were just taking advantage of it, like California likes to do, is they would do the background check, they would sit on it, and they would just say, well, you can have it in 30 days. Basically, doing their own subversion of the law in order to make people wait as long as possible. So Campos V. Bonta, there's a win. It now says that, look, California, you can't extend it out unless it's for the reasons that are already in law. Now, obviously, California can go and they can create whatever new law they want and try and extend that out, but that could be challenged. I think this 10-day waiting period needs to be in front of the Supreme Court as it is, because, whether or not you stop somebody from practicing their Second Amendment rights or First Amendment rights for 1 day, 2 days, 5 days, or 10 days, you're still stopping them from practicing their rights. So whether it's 10 days or 30, that's already unconstitutional to me. So I think that this needs to be overturned completely. But at least it was nice that the courts basically put the California DOJ in their place and said, look, you can't do this. And short staffing, that's not going to be an excuse. That's not an excuse to withhold somebody's rights from them for a month plus. And I remember in California, that stuff sucks because you got to pay for it. Sometimes they'll let you put down a deposit, but you got to pay for it. You got to do the paperwork. You got to go through the steps and all your processes, right? And if it's your first time, you got to go through a test, and you have to pass that test by a certain percentage, and you have to do all these extra things, jump through all these extra hoops just in order to complete the purchase. And then after you've done all that, they still make you wait 10 days. And it's so out of control there that even just a little bit of reining in some of that just, unchecked power that California has over people who like to practice their rights is a good win for me. So it's just one more step in the right direction, and there's some more coming down the pipeline as well. We have some other big cases that look like they might be a big win for California. I mean, we're talking huge wins. As a matter of fact, there's some cases that have been sent back down to Judge Roger T. Benitez, and you know where he stands. So fingers crossed on those, and I will update you as soon as we hear anything on those. So anyway, I want to thank you all very much for watching. I really do appreciate it. Please like, subscribe. You guys have a great day.